So for the sake of our recording here, we are starting with just a recap of AMA review options, requesting any questions on anything we discussed last week, and then we're going to dive right in with higher level review and then go into board appeals, and then move on to effective date issues. And so if anybody has questions that we covered last week, please ask away. All right, hearing none, we will dive right back into higher level review. So we discussed last week how supplemental claim review, you need new and relevant evidence. At least you're identifying new and relevant evidence when you're filing for supplemental claim review. You then have to provide new and relevant evidence to get supplemental claim review, get a decision on it. And very often when you request supplemental claim review, the veteran is going to get a new compensation and pension examination and or medical opinion. And that's a roll of dice in terms of what examiner you get. Could be great, could be not so great. And Katie last week went over if you get a not so great examination experience that leads to a proposed reduction, severance, or discontinuance of any sort of benefits, what rights a client has then to seek relief from that. Higher level review is different in that it requires no new and relevant evidence. Instead, you're telling VA, you got that decision wrong. I want to take it to a decision review officer, which is higher level. That's the higher level reviewer, higher level reviewer in higher level review, more experienced adjudicator who takes a fresh look at the evidence that was in the file as of the time you got the initial claim decision or supplemental claim review decision and says just straight up in terms of their own analysis, can I grant this now? And if I can't grant this now, is the reason that there was some duty to assist error that VA committed before issuing its decision that denied you. If the higher level review decision review officer says that there was a duty to assist error, then what will happen at that point is the decision review officer is going to return the issue back to the supplemental claim lane for VA essentially to clean up its own mess. The line reviewer then to issue a new decision. And while they're doing that, the evidentiary window reopens and you get a new decision that is that is essentially a new supplemental claim decision. You then can take a higher level review of that. You don't have to, you have other options as well. But that is the overview of higher level review. It's essentially taking a decision to the manager. We're going to discuss when to choose that instead of supplemental claim review, when to choose it instead of a board appeal, and when to avoid higher level review. Key fact about the decision review officers, they, like VA's line officers in the regional office, they are not attorneys. They are, however, bound by agency procedure manuals, including the M21-1. When you are making your arguments to a decision review officer, you can throw in case law, you can cite statutes and regulations, but they need to be like tucked in behind citations to the M21-1 manual whenever you can do that, because the M21-1 manual is their body of law first and foremost. Everything else is great for, supporting your case if you need to go up to the board. It's great too because a lot of the decision review officers, not all, but a lot, they're familiar with cases. And if you remind them of, hey, this is Saunders, and then give a brief description of that, they'll either look it up, or they'll say they'll look it up, and I do trust them, or they know it and they can speak that language immediately. And so for shorthand references for, these big topics that they're going to see in the M21-1 manual, if there is undiagnosed pain, then that's going to be enough for a disability and suffice for service connection instead of requiring a formal clinical diagnosis. Go for it. But by and large, just
I'm
remember
going to be
that
in the office after this is over. All right.
um, yep, nope, no worries. Heard somebody coming off mute. And so that will happen from time to time. No worries. When you are speaking to the decision review officer, you are citing the M21-1 to them first and foremost. And just the way that a line officer at the regional office is essentially, if you were suing Allstate or another insurance company, private insurer would be sort of a claims handler. This is like a claims handler's manager, somebody who's more experienced. They've been around the block a few times. They have an entrenched view of what the law is, or at least what their policy manual says, and they have seen many, many, many cases. That can be good, that can be bad in terms of you start getting jaded sometimes, or at least it's a risk when you see lots of cases, but it is a different experience. In order to get higher level review, you need to be challenging a VA decision, and in particular, a decision from supplemental claim review or on a new formal claim application from within the past year. And when I say a decision, what I'm actually referring to is whenever VA makes a decision on formal claim application or supplemental claim review, it will issue a notice of rights letter or notice of action letter together with the rating decisions narrative. It is the date of the notice letter that starts the clock for you. That's the easy case. There's a harder, or at least a gray area right now where we're trying to get law on, where you have filed for higher level review and you get not a notice of action letter with a rating decision narrative back, but you get a rejection letter saying you filed on the wrong form. This is not timely. Some reason why VA is not going to process your request for higher level review. Real question there, an open question right now, and I believe that most in our office believe we have an answer to this, and the answer is yes, but VA doesn't agree, right? Is that letter rejecting processing of your application or form, is that a decision? We say yes because we view it as essentially a dismissal, where VA is telling you, their shoo, we're not going to do anything on this, and that's appealable, challengeable under any of your review options. VA is saying that's not a decision. You can't seek review of it. And if you want a relief, that's in the land of you need to go file a petition with the Veterans Court, which has very strict standards, as we're going to discuss in later court level training session. And so, in the meantime, while that's unsettled, I wanted to make sure to mention it because you can get into a circumstance where either protectively or because you think you're right on this, you are filing for higher level review on something that VA doesn't think you can seek higher level review of. They reject it. You seek higher level review of the rejection letter. They don't think you can do that, so they reject it. And you can get like 4 or 5, 10 layers deep in this nested requests for higher level review and then rejections from VA with getting nowhere. When I'm in that situation, I used to be filing the 11th, 12th, 13th because I mean, come on, VA. But in speaking with clients, there's a point where they're like, okay, stop, just file a supplemental claim review and we discuss that option and do this, here's the correct form, the form you're requesting as our new and relevant evidence, seeking acceptance of our adjudication of this underlying entitlement. And so we've discussed a little bit how that can be the way to go, at least to break that loggerhead. And then from that point forward, you get the grant and you might be talking about earlier effective date based on, hey, I've been continuously pursuing, you've just been rejecting, and you can take it from there. Process for the 0996. That's a VA form that through which you seek higher level review. I like to, and there are some advocates who like to put their argument in that form itself. And that is not an unreasonable way of doing things. When VA collects up your documents, your submission, if you have like a quick submit cover letter, a substantive cover letter, VA form 20-0996, the form for higher level review, it's going to go through a scanning vendor. And the vendor is then going to deunitize your documents. And then it's going to have third-party correspondence. It's going to how it's going to appear in VA's electronic database, VBMS, to the decision review officer and anybody who looks in terms of the quick submit cover sheet. Third-party correspondence for your substantive cover letter. VA form 20-0996 for the form itself. And then what we do like to do is we'd like to attach legal argument and write on the 0996, see attached. And in the cover letter, see attached argument, or to that effect, where we are saying this is part of the 0996. This is legal argument you need to see, decision review officer. And that can get coded as quote unquote third party correspondence and overlooked by the higher level review decision review officer. And we don't like it, obviously, when that happens. The reason why we choose to do those attachments is that when we're preparing that legal argument, we end up taking more space than is available on the 0996 form to really do justice to the argument. And so in our assessment, and there are certainly multiple reasonable views on this, taking that additional space, getting into that additional detail of here why on the M21-1 you are wrong, you are wrong, you are wrong. Here, based on the records, is why the veteran needs to win right now. And just wrapped everything up with a bow around it. We find that to be a successful approach, and that's our preferred approach. With the higher level review, what'll happen is after you file that form 0996, VA is going to route the issue to the decision review officer, who, if on that 0996, there's a section of check boxes where you can request an informal conference. That is a teleconference between the representative and the decision review officer to discuss the issues. Typically lasts 15 to 30 minutes, depending on the complexity of the review. And so if you've requested that, the decision review officer is going to decide the case, will hold that conference, and then they're going to decide the issues on review, grant, deny, or finding duty to assist error. We discussed last week a little bit how in terms of timing, VA has been targeting 125 days between your requesting higher level review and you receive the decision. And historically, it's not been terrible about that for higher level review when you're looking at the timeliness with which VA completes their review requests. Most are within 125 days in terms of getting that up or down, or I guess neither up nor down, from the decision review officer. In terms of, though, success rates, at the beginning of the Appeals Modernization Act system, there were real questions about whether the decision review officers would actually give their own review, de novo review, from scratch review to these issues that at least nominally were coming to them as if nobody had ever decided them before. There was concern that they instead would show deference to the VA's line officers, that they should be reviewing from scratch, and early returns bore that out. You had very low grant rates and higher level review for the first few fiscal years, and arguably even today. But that grant rate has been increasing over time to the point where it's, it used to be 14.5%. Now it's 24%. That's about a 60% plus increase in terms of the percentage of higher level review requests as to which decision review officer is granting at least one issue. And so when I'm presenting the higher level review option to clients, I discuss with them the historical percentage, and you can't guarantee future results based on past performance at higher level review. But it's also good not to turn a blind eye to overall the industry's experience with this part of the process. And so it can be worth a shot. There are certain issues where I find decision review officers to be very good at, and there are others for which it can be it's a shot to get a decision within 3 to 4 months, so you can get a grant, but the odds are against any higher level review decision coming back favorably as to any particular issue in terms of getting an immediate grant. I mentioned driving factors here, more experienced adjudicators that can help them see things the way that VA or at least the Congress intends, but also more entrenched adjudicators that if they have been brought up the wrong way and their training has led them astray, they are in danger of being an adjudicator who gets 15, 20 years in their career. They might have developed a less flexible view of things, and so there are some you just get back straight denials, maybe however many issues you have. Question then is when to choose higher level review over supplemental claim review. I like to go to higher level review whenever I am looking at a medical opinion or failure in VA's duty to assist that is affecting things in terms of how VA looks at my client. And so if I have a medical opinion that is calling my client a drug addict, that is calling my client a liar, that is, uh, missing the boat in terms of what's wrong with my client. The longer that that medical opinion or examination report sticks in the record unchallenged, I worry about it festering. And essentially, you can see medical opinions and examination reports down the line, then referring back to it, incorporating opinions from it, leading to more trouble down the line. So I want to kick out that bad opinion as quickly as I can. This is a situation, right, where a supplemental claim review, you're saying, VA, you're not right, you're not wrong, but here's more evidence, reconsider, please. Higher level review, you're saying you were wrong. You made mistakes. And so you're calling out that examiner as saying you're wrong. Let's throw out that opinion, that medical opinion or examination report. Unfortunately, in most cases, the remedy for a bad opinion is going to be a new opinion, but at least then you get that bad one not completely off the books because it's still in the record, but you have then a repudiation of it from the higher level review saying that it's inadequate for rating purposes. So if ever it were to rear its ugly head again, you could then go back to that favorable finding from the higher level review officer and saying, no, you can't be looking at this anymore, VA. So bad medical opinion or examination report, I like high level review for that, as opposed to supplemental claim review. A failure in VA's duty to notify, these are difficult issues for an attorney represented or an agent represented who's accredited veteran to win on because they have enough notification, enough notice to be able to file for higher level review. But if you're looking at a rating decision narrative that just says denied, or if it says, and we see this sometimes with special monthly compensation for aid and attendance, where it's just regurgitating the relevant regulations and not even saying anything about the facts of this case, but just at the very, very top, there's the way they've labeled it is special monthly compensation based on regular aid and attendance is denied. You don't know why they're denying. And so that is a valid point to raise with the higher level review decision review officer saying, I'm in a bad place here. I'm arguing de novo review of a denial that I don't understand. And then you make your affirmative case as to why the client should win. And then also argue, hey, if you can't grant now, at the very least, let me have a shot about knowing why it is that my client's been denied here. 38 USC section 5104B, if you're just, as far as the statutory site, you tuck in behind the M211 site, says very plainly that there's a lot that each VA decision maker has to do in terms of not just providing a decision, but explaining it. And so you have good grounds then to get at least some relief there. I also like higher level review for what I describe here as intermediate complexity, frequent errors that arise from the line reviewer overlooking facts. So the presumption of sound condition, where when an individual enters military service, they're going to be presumed to be free from defect, disorder, or infirmity, except as noted in their entrance examination report, or as VA shows that they had by clear and unmistakable evidence, they had a pre-existing condition that was not aggravated by their military service. There are many decisions out there that just look back and say, yeah, you had asthma as a child, and so we're going to deny service connection for asthma because it pre-existed service. Well, no, that's not the standard. You need to show by clear and unmistakable evidence that the asthma continued throughout that childhood, was an active thing when entering military service, and was not aggravated by service. And frequently, VA is just not developing medical opinions to that strict standard. And their line officers, it's something that they frequently overlook. Decision review officers are much better about catching it, at least in my experience. When you say, yeah, there's no clear and unmistakable evidence here of pre-existence or of aggravation, then they get that argument. Limiting analysis of service connection to a single theory. VA has to look at, when you're claiming service connection, at every possible legal theory, whether it's direct service connection, presumptive service connection, whether you're talking about, when I say direct, I mean in that sense, A happened during service, causing B the injury today. But extending that concept to include the principle of secondary service connection. A happened during service, causing B medical condition that caused or worsened the C medical condition that I'm claiming today. VA has to look at that too. Again, line adjudicators often overlook that point. Examiners often overlook that point, and it's a point that the law very plainly requires VA to consider. Again, higher level review is pretty good at identifying that. I had mentioned last week, at least in passing, that I do not like supplemental claim review for earlier effective date issues. One area where in that I tend to take those, I think, straight to the board, and I'll be emphasizing that point later today. One exception to that is VA overlooking an intent to file. If you filed an intent to file on January 1st, 2025, and client filed a 526 EZ on February 1st, 2025, VA then grants whatever entitlement effective February 21st, 2025, they need to go back to January. That's a very clear-cut error, and higher level review can be a good stop there to get, a quick decision in terms of it should have gone further back. And whenever you're talking about earlier effective date, time is money. You're talking about if you have a 5-year appeal, you're losing the net present value of what VA already should have paid that client. And so it's for all sorts of reasons. You want to get that taken care of ASAP. Um, if the client wants you to speak to the adjudicator, then great. And if they don't trust the supplemental claim hearing process, another reason to go to higher level review. I also have on here very specifically TDIU with certain thresholds. This is based on my experience. People are going to have different experiences on this. When I have a client with a psychiatric condition rated at 70% and a physical condition that is rated significantly, and here I'm thinking musculoskeletal conditions. VA has, in my experience, had a little bit of a tougher time for TDIU between 70% psych and 50% migraines. A much tougher time with 70% psych and 50% sleep apnea. But if they have a 70% psych and 40% back, maybe with some radiculopathy thrown in, that looks really good for TDIU. And I've had relative success seeking higher level review versus just going supplemental claim, or straight to the board when you start adjusting for time there. And so that's another checkpoint for me in terms of, hey, is this looking for higher level review or a different review lane? Higher level review versus board appeal, right? And this is going to harken back to a lot of the factors we discussed last week in terms of the board has been taking a very long time to issue decisions. The board's grant rate is not super much higher than the higher level review, and its remand rate is about 29%. And so when you appeal to the board, you wait 3 years, you get a remand back to the regional office to fix its own mistakes, and that goes then, we'll discuss back to the supplemental claim review lane. What you've done is you requested a 3+ year supplemental claim review, which is terrible for everybody. And so I really have placed historically, I have placed a thumb fairly strongly on the scale of higher level review versus board appeal when the client is not 75 years old, is not in severe financial distress, and I am not feeling confident the board is otherwise going to grant advancement on its docket. And there are a couple other bases for it we'll go over. Our success rate on those have been low recently. So that becomes then, it rolls into the need for speed, really trying to get the client to win as soon as possible. There also are some issues that are beyond the board's jurisdiction. And so, for example, the board has no jurisdiction to address medical determinations. We represent clients through the caregiver program, and that is a Veterans Health Administration run program that is rife with medical determinations. It also has some non-medical determinations which can go to the board, but if I get a decision back that is, hey, this is not in the best interest of the veteran to do this, I'm looking at a Veterans Health Administration, either supplemental claim review if I have new evidence to add, or if I think they just got it wrong, then higher level review. Try to get a favorable decision or get resolved that medical determination point, and then if there are legal errors, right, they are, say, miscalculating the veteran's combined rating percentage. Caregiver program requires a combined percentage of at least 70, and if they're, say, not applying the bilateral factor and they have it as 60, that would be a great appeal for the Board of Veterans Appeals. When to avoid higher level review. So if you are trying to get review of what you believe is a VA error of law to include that VA has been following a provision in M21.1 that you believe to be unlawful, higher level review has nothing for you. The decision review officer must follow what the M21.1 says, whether it is lawful or otherwise, and so that's going to be a denial. I also have had very much difficulty getting good results from higher level review in terms of more sophisticated legal issues or legal issues that are pursuant to new precedents. So earlier effective dates, again, to highlight other than you missed the intent to file. In earlier effective date issues, we're going to discuss more beginning today. Exceptions to finality, such as 38 USC or 38 USC, 38 CFR section 3.156B or C, and then long pending unadjudicated claims. Nobody at the regional office has been great at granting special monthly compensation based on need for aid and attendance at a rate exceeding SMC L.5, or in some cases, if you have an additional single disability rated schedulally as total. They've been overlooking the Berry decision of the Federal Circuit. And that could be a decision, as Kenny discussed, I think a couple weeks ago, between some intermediate rate in SMCO or R even, which is a huge, huge difference. And with just no relief inside of the regional office, we've been taking those issues straight up to the board. I see that I have missed a chat here where Katie saw an unusual situation yesterday. June 23rd rating decision, June 23rd NOD to the board. Is that June 23rd or June 2023?
2023.
Okay. So you have a June 2023 rating decision and notice of disagreement to the board. 2 months later, you have a board denial. And then after some delay, a May 2024 HLR request.
So it was like, at first I thought you can't HLR a board decision, but then I thought, can you HLR the rating decision after the board if it's still within a year? Sort of odd.
No, you may
Huh.
not. So what that is going to be considered is so when there is a board decision, a board, say, just denial of an increased rating, and then the case goes back to the regional office, there will be an implementing decision. And the implementing decision will be to the effect of, I don't know, 30% evaluation for migraines is confirmed and continued. And instead of having a rating decision narrative, they're going to give you a copy of the board's decision. If you take a higher level review of that, what is going to be held is that you're not providing any new evidence or new basis on which to challenge what ultimately is the board's decision that the regional office was just implementing. And so what your HLR is going to be in a perfect world construed as is going to be a request to the board for reconsideration of that board denial. It's going to be a request, it has to be made within 120 days in order to preserve then if you lose that request for reconsideration to the board, to be able to appeal the board's decision up to the Veterans Court. But it is not going to be accepted as a higher level review of the implementing decision of that board decision. That turns out to be a very good question. Now, if the board had granted service connection for sleep apnea, the implementing decision says, we see you've granted service connection for sleep apnea effective February 1st, 2025, overlooking your January 1st, 2025 ITF, and assigning a 0% rating where the evidence of record that it was properly before that's interesting. We'll say it's properly before the board, that says that the veteran is using a CPAP machine. At that point, the implementing decision is going above and beyond what the board actually decided. The board's decision was to grant service connection. The regional office's decision that comes after the board decision is implementing the grant of service connection, and then it is newly deciding rating 0% and effective date February 1st, 2025. If you have a problem with the rating decision, or I'm sorry, with the rating assigned in that rating decision, or the effective date assigned in that rating decision, you can take higher level review as to either or both of those. So for higher level review, I like it for intermediate complexity. I also like it in terms of, is this a garden variety ultimately duty to assist error that I can get the medical opinion thrown out at the higher level review stage? And then if there's a return, ultimately VA's concern is that they don't have clear enough evidence to grant the entitlement. And to me, it is the lesser of two evils to go get a 3 to 4 months higher level review and then either a return to the supplemental claim lane that can take another 3 to 4 months, a little bit less now. They've been going down in terms of their average time to decision on that span of things, or a very quick supplemental claim review, adding new evidence that would help, right? So then you're talking about a total time that remains far less than a board, the wait for a board decision. And so I prefer to take those essentially 2 bites at the apple, well within the time I can get a single board decision and just trying to fix this garden variety mistake that the regional office made. I like to try to keep those types of issues down at the regional office as long as possible, so that things move as quickly as possible and the client gets as many people looking at that as we can. And in the average, that ends up getting more awards sooner for our clients than taking things straight up to the board. The exception being that if our client is 75 years old or otherwise is going to be advanced in the board's docket, then you're talking about, instead of a multi-year wait, something like 4 to 8 months we've been seeing, and you get a deeper level of review as we are about to discuss. Board appeals, when to choose them instead of supplemental claim review, instead of higher level review, and when to avoid them. So first of all, you're going to a different tribunal. Instead of being at the agency of original jurisdiction, which typically, at least for Veterans Benefits Administration type claims, is going to be a regional office, you're going up to the nationwide Board of Veterans Appeals, where then you get a decision from a veterans law judge who has been appointed, and they're assisted by a staff of 4 attorneys. And so these are people who are knowledgeable in the law, not just VA's policy. They're going to be bound by statute. They're going to be bound by regulation, but they are not bound by the M21-1. And so if the M21-1 goes against you, you can take that up to the board and potentially get relief right there. Similar to higher level review, you need to be challenging a denial for which VA provided notice within the past year. And now, instead of using the VA form 20-0996, VA has a separate form. They have a form for practically everything. This form is the VA form 10182. You're going to fill it out, identifying the specific issues that you are challenging, and you then are going to make an election in that form between the board's direct review, evidence submission lane, hearing lane. If you go with direct review, you, similar to higher level review, are saying you were wrong, regional office. We need a grant now based on all of the evidence that was already before the regional office at the time of their decision. And more specifically, all the evidence that was before the regional office at the time that they made their most recent decision for which the duty to assist was open. And so when I say that, I mean, if you get a supplemental claim decision of which you seek higher level review, that is a denial of which you then seek board appeal, you have to be relying in that board appeal, if it's in the direct review lane, on the basis of the evidence that underlay or that was of record as of the time of the supplemental claim review decision. The higher level review decision essentially gets passed through, and the board goes back to the time of the supplemental claim review decision. The evidence submission lane, you do have an opportunity to submit written evidence within the 90 days following the filing of the 10182. That ends up, for, unless you're talking about an appeal that's advanced on the docket, not a terribly long time. And so you better have an idea of what it is you want to submit within the following 90 days when you're turning in the 10182. Alternatively, there's the board's hearing lane, where you're going to prepare your client for, and they're going to participate in a board hearing, following which the client's going to have 90 days to submit additional written evidence and argument in support of their appeal. And I wrote in and argument there. Technically, you can submit argument at any time before the board's decision. There is a group of veterans law judges out there, though, that are going to, you're going to have trouble getting them to look at argument that you submit after 90 days following a hearing. The reason is that they're going to want to get that decision out. They're probably making preliminary notes, or they're having one of their staff attorneys make preliminary notes on the decision within that 90 days. at least preliminarily. And then if you add more evidence or argument within that time, you can affect that. And if not, they're going to get to the decision. VA then is going to route that appeal to a veterans law judge who, if there is no hearing, they're going to assign one of their staff attorneys to draft the decision. And then that attorney is going to confer with the judge, and they're going to go back and forth until the veterans law judge is happy with the decision. If there is a hearing, then the veterans law judge is going to conduct the hearing and then assign the appeal to an attorney to work up for a decision. Now, time from your review request to decision. This is the big thing. VA's target has always been within 1 year. If your direct review, 18 months for evidence submission lane, 2 years for hearing. And they've fallen very far short. Very far short. This time last year, our team was seeing 42 months, roughly on average, for direct review. We do not have a time estimate, in terms of average for evidence submission lane or hearing lane, because those appeals were taking so long to process. We had too small of a sample size where we'd gotten decisions back. The board has been focusing, it's getting enough case. So I'm going to take a step back. Roughly 10 to 12% of the board's docket qualifies for advancement on the docket. 10 to 12% of the appeals before it. Depending on the review lane, whether it's direct, evidence submission, hearing lane, somewhere between about 48% and nearly 2/3 of decisions that the board has been providing over the past several years have been on advanced on the docket cases. What this means is that the board is falling behind. The only cases that it's getting, or at least the first 48% to 2/3 of the cases is able to get through, are the advanced on the docket cases. And so if your case is not advanced on the docket, it's getting pushed further and further out. Now there has been catch up by the board, at least in the direct review lane over the past few months. And I hope that continues. But we really don't know. Evidence submission lane is still taking forever. Hearing lane, we're starting to see decisions coming back from, at least hearings being scheduled for. And so it's been slow. Clients have been unhappy. We also, it was when AMA came out, we thought board decisions in 1 year to 2 years, great. Those are higher quality decisions than we expect for higher level review, what we thought would defer to supplemental claim review. They're better adjudication, going through page by page of the record and understanding the law than supplemental claim review. And we bet big on board appeals as a firm. We had probably 1/3 of our cases that went up to the board in early years in the AMA, that many of which are still there today. And so it was it's a big deal how far behind the board is. And it's also a big deal that when the board talks about their timeliness, they're not splitting out in terms of average days to complete appeals. They're not giving subgroupings between advanced on the docket cases and non-advanced cases. And that is skewing their data towards showing that, hey, if you look at all the cases we're deciding, we're not so far off from our targets. Well, yeah, but look at how many advanced the docket cases those are. I will address, there's a comment in the chat. It could be a topic for end of the presentation as well, but Katie's might have been referring to Terry versus McDonough. Citation given 37 Vet App 1 2023, which seems to indicate that a May 2024 higher level review of the June 2023 rating decision would still be permitted despite the denial. There is I'm going to add a fact here. My understanding is that Terry addresses a case where you first have supplemental claim review, and then you have higher level review, and then you seek a board appeal. May you in that board appeal seek review of both the supplemental claim review decision and the higher level review decision? And the answer is yes. You may do both, but the distinguishing factor between the scenario that Katie had asked about in the comments is that there's something going on in that implementing decision. And so I believe it's Encarnacion is the Veterans Court case that says we're going to treat that as if it were board reconsideration. But again, if you have the grant of service connection by the Board of Sleep Apnea, it goes back to the regional office. Their implementing decision is to, recognize the grant of service connection, but give you a terrible effective date and rating. You see you can seek supplemental claim review of that, add in more evidence, you get a denial, seek higher level review of that, claiming legal error in that denial, and you can take both up in the same appeal to the Board of Veterans Appeals, and it's going to be looking then at both. In the I'm realizing I'm reversing things from Terry, where Terry, there's a higher level review decision and then a supplemental claim review decision. And so let's add then, right? Higher level review decision. You still don't get that relief. And instead of going immediately to the board, you try again, supplemental claim review. Here's a new medical opinion that shows I've had CPAP and I've needed CPAP machine for the last 18 years. I need to be at 50%. Well, then you can take with the higher level review decision and the subsequent supplemental claim review decision, where then you're looking at, from the board's perspective, at a legal error in the higher level review, and then on the different factual basis, right, an error in, and also for that reason, failing to grant the 50% initially. You can take both up. I apologize for reversing that. If anybody is still confused on that, I'm happy to spend more time on it. When you go to the board, you do get a higher overall in terms of statistics rate of success in terms of at least a partial grant, 30, when you were comparing to higher level review, 37%, but still remand of nearly 29, nearly 30%, which is awful. Awful. I want to kill all board remands under the AMA. I think they serve no useful purpose for the veteran, and I would rather have a grant or a denial that then I have control over in dictating the supplemental claim review. So then board appeals, when to choose instead of supplemental claim review. Hey, if your client's 75 years old, they're going to be automatically advanced in the docket these days at the board. Go for it. You're talking about 4 to 8 months for board review, 5 to 9 we've been seeing for supplemental claim. Less now, call it even, right, in terms of timing. Go get a veterans law judge who knows the law and has a 4-attorney staff to decide that for you. Severe financial hardship is closer for me. The reason is that the board may advance it's any case on this docket. It's the word may in its regulation for any of these circumstances in terms of whether to grant advancement on the docket. And so for age, it's doing it. Great, automatically go for it. For severe financial hardship, there's a real question then of, well, what is severe? What do you have to do to show the severity? And then persuading the board that this is a case where they need to advance on the docket. You're likely to be waiting at least a few months to get a decision as to whether to advance the case on the docket, during which time you could have been developing things at the regional office. There's no guarantee that decision based on severe financial hardship goes your client's way. If you lose it, you can re-up with a new motion with new, worsened facts in terms of financial hardship. But your client can be then trapped. They're waiting for a board decision. The board's not advancing it. And unless there is a violation that is so clear as in Heller versus McDonough, again, great Veterans Court petition case saying that the board was unlawfully withholding or unreasonably delaying its decision and refusing to advance on the docket and facts before it, it's not a good place to be. And so that is riskier. I always talk through the client when before filing with the board, even if we intend to move for advancement of the docket solely on the basis of financial hardship. I also, go to the board if going back to the regional office or agency of original jurisdiction is futile. If you are doing a Berry issue, for example, good luck. Go to the board on that. It would be my advice, at least for right now, until there's a stronger N21 provision that then helps the regional office to see, oh, this is how we're supposed to treat these additional 50% combinations in addition to what requires a attendance. If the client wants to submit a new private medical opinion without there being a more or less automatic VA opinion, board decision evidence submission review or hearing review can be the way to go with this proviso. There's a case right now pending before the Veterans Court that is looking at, hey, what is the purpose of a board hearing? Can you add new evidence after the regional office decision comes out in the hearing lane that then shows that there needs to be a remand? Does it have to show that there was a pre-decisional duty to assist error, which I believe yes, and the case I believe it turns out where you can add new evidence, but it has to go to show that before the regional office made their decision, they made a mistake. Versus I'm adding new evidence now, and so I think you should remand. What you may do at all times in all appeals at the board is add new evidence and ask that board to grant on the basis of that evidence. The board has an evidentiary window again that opens up either 90 days in the evidence submission lane following your submission of the 10182 or 90 days following the hearing in that lane. And if you provide evidence that is strong enough, even if it is brand spanking new, the regional office never looked at before, that the board can grant pursuant to 38 USC section 5103 capital A little f number 2 big A 5103 F2A 5103A F2A, the board has to grant if it can grant, and so go for it. Renee has a veteran who has served in both active duty and reserves and across several branches. There's a thought as to whether the only option to get a grant is to go before the board to explain that service to the judge, supplemental claims, and higher level review that is younger and 40. Yeah, I think that's a board issue. Regional office has a very difficult time with our veterans who have more frequent ins and outs between active duty and reserve service, and which is unfortunate because there are so many of them, and this affects. But we've been seeing the same problem at the regional office. I'd go to the board. Client wants a hearing before specifically a VLJ. First of all, I am checking to make sure they actually want a hearing before the Veterans Law judge and not just a hearing. If what they want is a hearing and really they should be in supplemental claim review, I am urging them to please consider supplemental claim review. You can get a hearing there. But if they want one before a Veterans Law judge, then so be it, right? Let's go for it. When to choose board appeals instead of higher level review, right? So same as above. Really, at that point, you're taking the way that I'm approaching board appeals versus lower level decisions, the board appeal versus any lower level decision, where I'm looking board versus AOJ at all. Now, when to avoid board appeals? I think a lot. And I'm going to say not as much as I used to. And the reason is that I don't know how the regional office is going to change over the next few months. And I have a lot of trepidation right now. I'm hoping wherever we can, right? If we can wait and see, I'd love to get more data. And I'm still like, I'm cautioning clients, hey, this is how things could go. I don't know where it is. There's a lot of uncertainty here. And so I'm not placing my thumb on the scale as strongly towards the regional office, towards higher level review or supplemental claim review. But it is a long time to wait unless you're going to get advanced on the docket to get a single board decision that still could very much go either way, including a remand a third of the time nearly, that just puts you in very long supplemental claim review. Any questions in terms of your AMA review options before we move on to effective date considerations? I will invite questions to continue then as I am stopping share and loading up the presentation for effective dates. All right, seeing none, let's go. Understanding effective dates. What we're going to do is we're going to introduce the concept of effective dates, talk about general rules governing them, and then we're going to address the very important exceptions really while we're here, permitting earlier effective dates. So when I say here, I don't mean here practicing veterans law, I mean here today looking at this session, because what we're looking at is trying to correct VA's errors in this very important field. So what is an effective date? It's a concept that reflects that VA entitlements carry both a start date and an end date. When you look at an award's effective date, it's going to signify the time period over which that award is in effect. And so when VA knows both the start and the end date, you're going to see an entitlement as being, service connection for obstructive sleep apnea with a 50% rating effective from start date to end date. VA doesn't always know that, or it's still open, right? The VA will make a continuing award. So service connection and a 50% rated for obstructive sleep apnea effective from January 1st, 2025. We have this concept of effective dates because VA rarely receives, considers, and grants a claim all in the same day. I believe Katie had spoken to this. Sometimes it happens. You can have clinics set up where people can go in and get file their claim, get examined, get a decision the same day, but very frequently not. And so Congress has made this choice that instead of when your grant beginning when VA actually completes its decision, VA generally has to then grant the entitlement retroactively to the later between when VA received your claim for the entitlement being granted and when the entitlement on a facts found basis then arose. There are a few key exceptions to that general rule that provide essentially grace periods for VA to receive the claim or that alter what VA must consider as constituting the claim being granted. Both of those are important. We're going to spend some time on each. In terms of when an effective period will end, well, generally this is reflecting some fact that changing that affects the claimant's entitlement. The claimant has died. If there is a financial dependency award that's made, then the child turns 18, the veteran gets divorced. The severity, if you're talking about a rating evaluation of a service-connected disability, either worsens or materially improves, and that improvement is sustainable over the ordinary conditions of life, typically, and so on. So there's something that is actually changing that is either improving the veteran's health scenario or otherwise is affirmatively ending this entitlement to which the veteran has proven to be warranted. So where effective dates fit doctrinally, and this is the nerdiest of my nerdy slides today, but stick with me because if you go look at a horn book, you're going to see that, or most decisions on it, most court decisions, you're going to be to see these elements of a claim for service-connected compensation as describing the claim as having three components. First of all, establish service connection. Second, you establish rating evaluation. And third, you're establishing the effective dates. 1, 2, 3, where effective date is a third element self-standing. I don't think that's the best way of looking at it. And what I follow the law when you're writing your briefs, but if you can keep in the back of your mind, hey, maybe I could be conceptualizing effective dates as adhering separately in each of service connection and rating evaluation. Service connection for sleep apnea effective January 1st, 2025. So there's the effective date as adhering that service connection component. And then you're looking at the rating evaluation. Rating evaluation effective January 1st, 2025 to then, VA can give staged rating evaluations. And so you think of effective dates for each component of that overall rating through time. In my view, that ends up being a little bit more precise. And then when you're writing up your VA forms 20-0995, 0996, 10182, it allows you then to be more precise in identifying what it is that you are seeking. And so decision review request, you could say, for example, effective date earlier than whatever VA had granted for rating evaluation in excess of whatever VA had granted for the service-connected disability. And you can tack on there if you want to include consideration of what you believe is the achievable maximum there. And I like to include that to include consideration of text because frequently, well, it's something the board can look to, or the higher level decision review officer can look to. And when I'm framing that up for them, I do find that I have a higher success rate of them actually giving what I'm asking for as opposed to them having to guess. That's the general concept of effective dates, the general rules for effective dates, right? So 38 USC section 5110 and its implementing regulations, particularly 38 CFR section 3.400 is where you see a lot of the implementing regulations for this. They go to, unless specifically provided otherwise, the award's effective date is going to be fixed in accordance with the facts found. But again, it's not going to be earlier between than the date of the receipt of application. So again, it is the later between when your client applied for the entitlement and when that entitlement on a facts found basis actually manifested. You get to keep that effective date entitlement so long as you are continuously pursuing issues in the Appeals Modernization Act system. So as long as you are filing a valid right 0995, 0996, or 10182 within 1 year of notice of a prior decision, you are maintaining that continuous prosecution of the entitlement. And so even if you take a case up to the Veterans Court, you don't file simultaneously supplemental claim review. Veterans Court appeal takes 2.5 years. It's an affirmance. You can then seek supplemental claim review within the year following that, hopefully sooner than that, and add in new and relevant evidence, and that effective date award can go all the way back to when you initially opened up that claim stream with the hopefully intent to file, followed by formal claim application or supplemental claim review application going on from there. Key considerations then for an assigning effective date are, number one, the date of the initial application's filing. Number two, whether there has been continuous pursuit or how long there's been continuous pursuit. And then number three, when in accordance with the facts found, the entitlement arose. Looking at the first of these, date of initial application. This refers to when VA received the first claim of entitlement for a benefit, either at all, VA refers to that as the initial claim, or after a period of continuous pursuit of that claim had ended. So then you have a reopened claim. And so put a finer point on that. If you had that claim for tinnitus 35 years ago, it was denied, and then now you're seeking supplemental claim review of service connection for tinnitus, VA is going to be looking at that as a reopened claim, a new claim stream. And in the first instance, it's going to be looking at when you filed. Okay, you filed your 0995 on February 1st, 2025. That's when you should expect to see VA granting the effective date. And we can talk about if there's an intent to file here in a moment. Now, in terms of when VA receives a claim of entitlement, usually it's looking for a formal claim application these days or a complete supplemental claim review request. But if you are opening up a new file, you're reviewing a file where the claimant has had proceedings with VA since before March 24th, 2015, you need to be aware that that was not always the rule. You did not have to file claims on prescribed VA forms. VA instead had to accept whatever you wrote it on as long as it was cognizable as a claim. So if you were on the, went out to dinner one night and you were saying, I wish I had this, and you just say, really my back is bothering me, I think it's connected to service, and you file that back of the napkin, that's going to be okay to start that claim. It's going to be considered informal because it's not on VA's prescribed form. But as long as VA received your informal claim before March 24th, 2015, it had to accept that then as a claim and then process it, adjudicate it, and then that opens up the appeal periods. Separate from informal claims is this concept of reasonably raised claims. And so when after opening up a claim, the claimant has provided evidence or argument that reasonably raises the question of an entitlement and that the claimant intends to seek that entitlement, VA has to accept it. I love the following example for this. I had a client who in 2001 in service was in a very bad car accident. And he was rushed to the hospital where he had screws put in his cervical spine. Very prominent, very pronounced cervical spine condition. Very prominent, very pronounced left upper extremity radiculopathy immediately and forever. He also was struggling with right upper extremity radiculopathy. He had the numbness and tingling, but it wasn't nearly as bad as the left side. He files a claim for the service-connected compensation of his physical disabilities stemming from the car accident to include the neck and his left side radiculopathy, left upper extremity radiculopathy. During the course of development, well, VA goes out and gets his medical records and sees from the medical records, well, yeah, you had affected, you tested your right upper extremity too, and you had 4 out of 5 in terms of sensory what you were able to do with your right upper extremity. That was damaged. And it goes to a C&P examination where the examiner says, yeah, this is a veteran with cervical spine disability and significant left upper extremity radiculopathy and moderate right upper extremity radiculopathy. And also you have comments during the same examination report where the examiner notes that veteran is complaining of right upper extremity radiculopathy as well as left. VA then many years of proceedings where VA is grants service connection and too low of a rating for the cervical spine, grants service connection too low of a rating for left upper extremity radiculopathy, ups and downs with that, and then finally we get to look at the case and we say, now what about this right upper extremity radiculopathy? What the Veterans Court held, and then on remand it was held by the board, was that that was reasonably raised. That when the client had been putting in for in connection, they had identified the car accident in their formal claim application, the neck, the left side upper extremity radiculopathy, the same accident, the care they received, it was the same thing that caused the left side and the right side, and then was submitted to a C&P examination of the right side as well. And then talking about how that's hurting, VA inferred an intent there, right, to seek service-connected compensation along for the right side as well as the left, and got 20 years retroactive compensation, 20% for right upper extremity radiculopathy. Should have been higher, combating for higher, but still not nothing. And so don't sleep on reasonably raised claims where in the developing the facts for something else that has been formally or informally back in napkin or prescribed form claimed with VA, that then VA is asking questions about and is getting this great evidence from the client about that, oh yeah, I need to seek this too, and it's there. All right, very important exception to those general rules on effective dates is the intent to file. And this is a 1-year placeholder you can provide that you can file with VA to provide essentially a grace period for developing a claim before giving VA all this stuff. And so if VA receives a complete application within 1 year of receipt of the intent to file a claim, VA will consider the complete claim filed as of the date the intent to file the claim was received. That's 38 CFR section 3.155B. What is an intent to file, you might ask? It is a VA form 21-0966. If a potential client calls you up and says, can you help me? You might consider responding, I don't know, we'll take a look at it. In the meantime, if you have not filed an intent to file, you might consider it. It's a great placeholder that you can put in now to protect your rights while we review your case. It's a VA form 21-0966. It's at this point, I believe, 3 pages long. It takes about 5 minutes to complete, and it can save a year of retroactivity. Fantastic to use. Why is filing one important? I'll say that we have an instruction to file an intent to file on every single new case that we receive. We always start with imperfect information. It takes us a little while to get through the claims file and see what we've got. For existing clients, there could be lag times between an entitlement arising and us learning it, right? Oh yeah, I fell last week due to my service-connected it could be peripheral nerves condition, right? My leg just or knee instability, and I broke my hip. And they just tell us about it 2 months later. Well, if we have an intent to file already in and active for the client, then saves them retroactivity between the time that hip broke and they told us about it. We then argue hip is secondary to the service connected, whatever it was that caused the fall. That's separately another battle with VA, but one that I would submit VA should grant the hip on. So my advice, always, always, always keep an active intent to file. If you file a VA form 21-526EZ, or if you file a more than 1 year, I would call them greater than 1 year supplemental claim review, you're seeking review of notice of decision more than a year old, that then is going to use up your existing intent to file. So a reason then to stack as many issues as, well, a reason, and there are ways to go both ways on there, the reasons to go both ways on this, but to make the most use of an intent to file, if you can reasonably put together multiple issues into a single 526EZ or a single beyond 1 year supplemental claim review request, that's going to get the most use of the intent to file. And the very next business day, you're filing a new intent to file because your old one is used up. Client calls. Why are you filing an intent to file? I didn't want to do anything. What is this? Well, it's purely protective. If VA gets a second intent to file while one's already active, its own regulations require it just to disregard the second one. Your first one remains on the books. Now, is there some low chance of causing confusion with VA and they look at the wrong intent to file? Yeah, that happens. It also happens that VA overlooks intents to file completely. I would much rather be in the position, and we have, I mean, over a dozen times an intent to file has come in to save the day within the past year and a half for us, where we're talking about, in some cases, major recoveries that because we had an active intent to file that gave more retroactivity. So please keep an active intent to file throughout all times in your cases. An illustration here of how intent to file works. The bottom line is that it's going to provide 1 year of retroactivity, right? So new client, January 28th, 3 days later, end of January. So you're protecting the month of January in terms of retroactivity, files an intent to file. And then you are filing later the 526CZ. It's going to go back to the date of the intent to file. Now, you can't string together intents to file. You can't say, oh, yeah, January 1st, 2025, I'm filing intent to file. December 31st, 2025, intent to file. December 31st, 2026 should be deemed to be. No, that doesn't work. You would get the at that point, your first one expires, and then you'd be arguing to apply your second one. Yeah, it would have been disregarded if my first one's active, my first one expired, so then go to the second one, your December 31st, 2025. So it's still going to protect something, but don't plan on stringing them together. I do think, and this is something that comes up in we're going to talk about the PACT Act later and effective dates going back, for liberalizing laws. So August 10th, 2022, there is the effective date of the PACT Act, which then created new presumptions for service connection for certain conditions. And as long as you're filing within the year following August 10th, 2022, VA is going to then consider an effective date going back to the date of the liberalizing laws effective date, August 10th, 2022. And so VA, then there's like weird system problems and something that ended up being August 14th, 2023, before VA stopped accepting claims within 1 year of August 10th, 2022. But for simplicity, let's say that on August 9th, 2023, you file an intent to file. August 9th, 2024, you finally file that 520, the Form 21 526EZ seeking service connection for a presumptive condition under PACT Act. Right. At that point, then, does your effective date go back to 2023 when you filed the intent to file? Or is your complete claim deemed received as of August 9th, 2023? And then because it's received within 1 year of the liberalizing law becoming effective, it goes back to August 10th, 2022. I think yes. I don't know what the courts are going to say about that. VA has not been super enthusiastic about that argument when we've raised it at the regional office, go figure. But that is the one exception that, it's not stringing together intents to file, but it is to some extent stringing together intent to file followed by liberalizing law provision or something else. And so if you have a client coming in this situation, right, do not fret for them, file for them, and you might be able then later to argue going further back than maybe initially contemplated. Now, self-filings hurt here. One of the very first communications we send to new clients is, we're okay with you making filings yourself. We get it. We'll stay in our lane. But if you're going to file something yourself, please let us know in advance so we can help prepare for it. If we get a surprise like, oh yeah, February 1st, I filed this 526EZ for hearing loss, and then we try later to file for all this stuff, well, all this stuff, it's not going to go any earlier back than when we filed, because, dear client, you destroyed the intent to file with your little hearing loss claim. And this happens, right? You do your best with clients, you tell them all this stuff, but it's another reason to maintain early and often communications with clients and to try to help educate them in terms of what their self-filings can or might do or would do in terms of the overall picture. For continuous pursuit, again, it's you start that timing with the date of the notice of denial. And then for legacy appeals, it's the notice of denial of the claim, and then 60 days for statement of the case. That's at this point more or less an aside. There aren't so many legacy cases that remain at this point. But 1 year from notice of a prior decision. So where does VA really mess that up? Let's put intents to file for aside for 1 second. Fridays to Mondays. VA issues notice dated February 5th, 2024. Deadline to file was February 5th, 2025. That's both midweek. Yeah, no problem. VA files or issues a notice of decision dated February 15th, 24. Deadline to file the challenge was February 18th, 2025. Why? Well, the 15th of I had the wrong date on that bottom bullet. I apologize. February 15th, 2025 was a Saturday. February 17th was a federal holiday. February 18th is the next workday. 38 CFR section 3.110 says that where a time limit would expire on a Saturday, Sunday, or holiday, the next workday will be included in the computation. And so if you get in a claim that looks just a little stale, but you're talking like a Friday to a Monday, or Monday was a holiday, and then you have Tuesday, get it in. VA must calculate that as being timely. They do mess that up all the time. Higher level review is pretty good at correcting that when properly explained to them. Now, in terms of facts found, you're going to get an effective date based on when the entitlement arose. For service connection, that means the earliest date as the evidence shows that the veteran had the disability, which here means functional impairment tending to diminish earning capacity, does not need a formal clinical diagnosis for most conditions. You're talking about musculoskeletal type conditions. Rating evaluation, earliest date as the evidence shows that the disability severity met particular rating evaluations requirements, and there can be a grace period. Big thing to note up front is the difference between the earliest date as the evidence shows versus the earliest date that evidence shows. So the key thing you're looking for is when the medical condition came to be or the severity came to be in the veteran, not when VA happened to receive evidence that then memorializes when that came to be or the severity came to be. If veterans started experiencing sleep apnea in 2022, immediately files a claim, and VA gives bad medical opinion after bad medical opinion, then finally in July 2025 issues a medical opinion that says, oh yeah, he has sleep apnea and I believe it's connected to service. And VA comes back and says, well, we have a medical opinion from July 2025. We're going to grant service connection and 50% from July 2025. That's wrong. You got to go back to 2022 when the sleep apnea manifested and the claim was filed, right? So the later between the two, not when that evidence came into the record. Now, you may put in new evidence. You may put in a 2025 opinion that says, yeah, this began earlier than 2022, and that's perfectly good. Again, what you're looking at is the symptoms, the manifestations, not the date of the evidence itself. Those are the big effective date concepts in terms of the basics. In terms of exceptions, and we're going to spend more time on this next week, I see. Liberalizing law, grace periods for filing, and then the really big exceptions to the typical requirements for continuous pursuit. Liberalizing law is an amendment to a statute or regulation that permits VA to grant something that it previously could not. So Agent Orange Act, 38 U.S.C. Section 1116 is implementing regulations, right? In terms of presuming service connection, for one thing, presuming exposure to herbicide agents, and another presuming service connection for certain diseases that are known to result from exposure to herbicide agents. Legislation establishing presumptive service connection in connection with post 9/11 service in the Southwest Asia Theater of Operations, the PACT Act. You know, all this can be good. Your client's going to receive service connection that VA previously would have denied, but it also can frequently lead to effective date errors. And what I mean by that is that typically when VA is granting under a liberalizing law, meaning the only way they see that they can grant service connection is under the liberalizing law, the effective date is going to be no earlier than the liberalizing law's effective date. You file within 1 year of the liberalizing law's effective date, you get the liberalizing law's effective date, August 10th, 2022 for PACT Act claims. Great. And then if it's more than a year, you get a 1 year grace period, like 1 year subtracted from the effective date. Keyword is only. The only basis on which you can grant service connection is that liberalizing law. What we see time and time again is we receive a file, veteran has been seeking service connection for X condition since like 2019. Call it hypertension here. Then this new liberalizing law comes in, and VA is like a hammer seeing nails. They're training up their staff and saying PACT Act, PACT Act, PACT Act, and they grant, effective from August 10th, 2022, service connection for hypertension under the PACT Act. And you say, no, that is great, great, don't disturb the grant from 2022, but you missed all of the proceedings from 2019. When I was saying on a direct basis, I can show from the facts here that my hypertension results from bad things that happened to me during service. So you keep on fighting for that 2019 effective date, and you show service connection on a direct basis or some exception to finality otherwise. And the grant of a later effective date, a too late effective date under a liberalizing law, you continue to challenge. And you see saying effective date early on August 10th, 2022 for service connection and if you have it, compensation, a consumer rating evaluation for hypertension. In terms of grace periods, Congress has created a few of them. One and a big one is that when a client exits, or when a service member exits active service, they have up to 1 year then to file their first claim, or any claim rather. Any claim that a veteran files within 1 year of leaving active service, the effective date for that claim is going to go back as far on a facts found basis to the date immediately following exit from service. This comes in handy all the time. Accepting clients who exited service September 1st, 2024, right? And that's going to be over the week. No, we'll say September 3rd, 2024, just for midweek here. We're going to have until September 3rd, 2025 to get in. Even if there's been another 526EZ, we think they missed something. Oh, you say your lower back hurts and you claim that, great. You have numbness, tingling, and shooting pain in your right hip going down to your lower extremity. And you didn't claim for that. Let's discuss how in some cases, not every case, but sometimes you can have a comorbidity called radiculopathy. And then if there's something merited there, file that 526EZ within the 1 year from exiting service. It should go back retroactively to the date immediately following exit from service. When you're talking about specifically seeking an increase in rating evaluation, here I'm not talking about saying that VA got it wrong. I've always used the CPAP machine. I should have been 50% from the start, but instead, yeah, last week I started using the CPAP machine. Or better, on September 4th, 2025, I was diagnosed to use or prescribed a CPAP machine. And September 3rd, 2025, just within 1 year, I'm filing for an increase from 0% to 50% on the basis that I now use a CPAP machine for sleep apnea. VA has a grace period of, it's 1 year so long as it's ascertainable when that increase in severity occurred when you're seeking an increase in rating evaluation, a new increase in rating evaluation. And so you had sleep apnea of a severity that did not require use of a CPAP or similar device until September 4th, 2024. You're filing, on September 4th, 2024, you have that new prescription saying, hey, just today is the first day when you can ascertain it got that severe. And you file within the year following that for a new increase. VA is going to backdate that then facts found basis to 1 year prior, up to 1 year prior, I should say. Additional grace periods are in terms of proving up the financial dependence. VA, when they make a new award that brings a veteran to at least 30% combined rating, entitling them to award to then financial dependency kicker each month, then they have 1 year from the date of that decision to provide proof. Claim for DIC is going to be within 1 year of the veteran's death. And PACT Act DIC, this is fantastic for surviving spouses of veterans. You get reevaluations of prior DIC, and you get to reopen up the early effective date, the original. Essentially get to go back in time as if this were an initial claim. And it is fantastic, fantastic, fantastic for spouses. It is so strong for spouses that when a surviving spouse comes to us who looks to have a PACT Act DIC claim, I tell them to go find a VSO, try to get it done for free, try to get that earlier effective date, and then if you have problems, come back. But in the meantime, that's too big of an award for not enough work. I think there was a comment in the chat here. Yes. What's your best practice for getting radiculopathy granted to the underlying effective date of the back or neck? So, big problem here. All right. What I want to argue, what I really want to argue is that when you claim service-connected compensation for a spinal condition, that is logically connected then to any claim for radiculopathy from that section, stemming from that section of the spine. You're seeking cervical spine condition, you get upper extremity radiculopathy, you have lumbar spine condition, you get lower extremity radiculopathy. And as long as there is a logical connection between the two, I read the Veterans Court's holding in the Bailey case, and I'll provide that citation after this meeting, or at least next week, if nothing else, that says that if you have a logical connection between the two, you don't need a separate formal claim application saying upper extremity radiculopathy. It's going to be subsumed within your claim of cervical spine condition. Big problem there is the Veterans Court's fairly recent decision in a case called DeHart, D-E space H-A-R-T, which carves out essentially because there's a separate rating evaluation scheme for radiculopathy that the Veterans Court is saying, well, it's logically connected, but there is this different rating evaluation set of criteria for radiculopathy. So we're going to retroactively expect folks to have it separately formally claimed explicitly the radiculopathy. I want to challenge that. I think it's wrong. And until we get done, with challenging that, until we lose every way there is to lose, I'm arguing ahead. And so I'm still making this logical connection argument that, yeah, I know the 526 EZ said cervical spine condition and then said nothing about upper extremity radiculopathy, but it is logically connected. And so we don't believe that the February 24th, 2015 amendments to the regulations regarding formal claim application change that underlying precept that if something's logically connected, VA needs to then investigate and adjudicate that issue as well. But DeHart does, in that case, stand flatly in the way. So if you were looking at a circumstance, then you have a claim you're looking at where the spinal condition predates, and the claim for the spinal condition predates March 24th, 2015, go for it with the logical connection, and go for it under the, hey, before March 24th, 2015, there were, informal claims could be accepted at all times, reasonably raised claims could be accepted, and this is a case where maybe either applies. But if it is a newer set of claims from clients, ones where the back claim does not predate March 24th, 2015, I still am making the same arguments, but I am tempering expectations because that's an issue that has to go up the federal circuit, and I don't know how it turns out. Now I realize I only read the first part of that question. So oftentimes we'll see continual pursuit of the neck granted to January 2023, and then radiculopathy granted July 2025, date of the first exam that actually asked about the radiculopathy and thus recorded it. VA denies on the basis of the C&P exam was the first date of objective evidence. Oh, grow up, VA. That's my response. You have been, now in this circumstance, I am assuming that there is enough out there in the formal claim application for VA to latch on to the radiculopathy as well as the cervical spine. And I am now saying that VA, what you're looking at is the date of the examination, not the date that the cervical spine first manifested with, in the radiculopathy, when the radiculopathy, in other words, first manifested. And so what I'm looking at there is then a supplemental claim review, adding evidence, speaking retroactively from the client, from somebody else who has observed the client over that time, talking about when the numbness, tingling, shooting pain symptoms of radiculopathy began. I'm thinking about, or at least encouraging the to the extent that there is free medical opinion available from say, a primary care provider, who'd be willing to say that, yeah, I've been treating the veteran for these many years. The veteran has presented with and then diagnosed it retroactively, radiculopathy secondary to cervical spine. Or if the client has to, and if the finances make it work for the veteran, right? They're close to 95%. This grant to either retroactively get them from 90 to 100, for example. Maybe they go out and consider a third-party opinion. Retroactive, saying, yeah, this is a 2025 opinion, but I've looked at the medical files, I've spoken with the veteran, I've seen this other evidence. On the basis of my review of the evidence of record, I believe that the radiculopathy first manifested long ago, enough so that you should then get the earlier effective date. So before March 24th, 2015, the initial claim, I'm arguing and feel pretty good about either informed claim application or informed claim or reasonably raised. Since March 24th, 2015, I am still making that same argument because I am going to try to overrule the heart. But again, tempering expectations. And if the issue is really that VA is assigning the effective date on the basis of an examination or an opinion, or what they're calling here the date of objective evidence shows, go out and get better evidence. Or when I say better evidence, evidence that resolves VA's concern about having evidence that goes back far enough in time. And if the regional office, they're getting really hung up on objective, and you keep on adding more lay testimony, at some point you take that up to the board and say, 5107B, folks, the evidence that has to be considered is not just medical evidence, but it's all lay and medical information of record, and get it granted that way. Long answer. I see we're at 90 minutes. I am happy to address additional questions. I have some time to stay after if anybody's interested, and if others don't have time or don't have, we will also have next week as well. All right, hearing no more questions for now, I look forward to seeing you all next week, if not Thursday.